Welcome, everyone. We're just going to wait a few minutes to make sure everyone has a chance to, get on properly to the webinar. We'll start probably right around 11 when we were scheduled to start. In the meantime, hope everyone's having a good day so far. Just another minute or two, and then we'll get started. All right, I think we will try to get started now. Hopefully everyone's successful logging in and getting on. So hello and welcome to our quarterly sample policy update series. We're so happy you're joining us for our discussion today that focuses on the March packet. Before we get started with the content of the policies, let's go over the layout of the webinar. Next slide, please. We will start with housekeeping and presenter introductions. Then we will move on to a brief poll to learn more about who is attending the webinar presentations. After that, we will learn about policy services and support that CSBA offers, then on to the policy updates. Before concluding, we will then conduct another poll. We're hoping for feedback as to how we're doing. And please know there will be time for questions and answers at the end of each section, as well as at the end of the full presentation. Next slide, please. And it's just for a few housekeeping tips. Please use the Q&A feature to submit your questions. This is located on the ribbon below the speaker. The chat feature has been turned off. Your questions will be answered either in the Q&A feature in writing or live by our presenters. All attendees will receive a link to the video of this webinar as well as the slide deck. So don't worry about that. You will have these materials will be forthcoming. And now for an introduction of our knowledgeable and thoughtful panelists. So next slide, please. So we have Josh Daniels, Chief Policy and Governance Technology Services, Meghan Russell, who's a Senior Policy Manual Writer, Dustin Bindreiff, a Senior Policy Manual Writer as well, Aaron O'Ray, Program Manager of Policy and Governance Technology Services, and then myself, Barbara Laifman, Director of Policy Manual Development. Next slide, please. So we're going to try to conduct a poll, and we thought since this is the first time we're doing it in this format, our last webinar, we actually did it, but we did it through the chat feature. We are going to kind of do a fun practice poll to start. And it's pretty simple. All you need to do is to click on the letter of the topic that you prefer. So our first poll, our fun one, is what is your favorite part of school? And you can choose academic subjects, visual and performing arts, recess and PE, or extracurricular or team sports. So please go ahead. I'll give you a few seconds to choose your favorite part of the school day when you were in school. Okay, we'll have like about 5 more seconds. 5, 4, 3, 2, 1. And Josh, now will you please help us with our results? Okay, so let's look at what the results are showing. It looks like the favorite is extracurricular activities or team sports. Then a tie between academic subjects and visual and or performing arts. And then the last is recess and PE. Okay, so now we are going to go to our quote unquote real poll. which is, and this will, let me give a little explanation for why we're asking about this poll. That the purpose of it is really to gain insight into who is attending the policy update webinars in order that we can focus our materials and presentation appropriately so that it's more meaningful to your positions within your respective districts and county offices of education. In other words, it's going to help us do our job better. So let's do the same practice that we did before. I'll read it off. The poll is, what is your role in your district? Are you a school board member, a superintendent or district administrator, an executive assistant, or do you hold another position within the district? And we'll take a few seconds again, and then we will look at the results. All right, let's let about 5 more seconds. 5, 4, 3, 2, 1. And let's take a look at our results. Okay, wow. So a lot of executive assistants. That's great. Welcome, everyone. Then next would be superintendent or district administrator. Then other, maybe we'll have to elaborate or learn a little bit more about what that other category is. And then a few school board members. So welcome, everyone. It's kind of nice to don't see your faces, but kind of can get a better sense now of who is out there. So thank you for doing that. All right. So Erin will start off by giving us a description about the comprehensive policy services and support that CSBA offers and using Gamma to access the update packet. Erin, if you could please go ahead.
Thank you, Barbara. Hello, everyone. I'm excited to talk today about how you can use Gamma to access the March update and previous update packets that we've got in the system. So if you could go to the next slide, please. So if you are accessing Gamma via our policy site, which we also call the sample policy site, and you subscribe to Gamma Policy but not Policy Plus, you will log into the sample site and find the update packets under the policies drop-down menu behind the policy updates link there. And you will see in the 2024 CSBA policy updates area where the policies and the guide sheet have been split out and are accessible. Next slide, please. If you are a County Office of Education user and you subscribe to Gamma Policy rather than Gamma Policy Plus, it's a similar situation where you will use the policies drop-down menu to access the policy updates. You'll navigate to 2024 and you will see that the county updates are there as well. They're defined by code C there in the code area, and it also says county update packet. Additionally, they're also split out into the policies and the guide sheet as well. Next slide, please. Now, if you are using Gamma Policy Plus and you have a site of your own that has your board policy manual or your County Office of Education manual in it, you can find the updates in your policy module drop-down menu under CSBA Communications. That first section there where it says CSBA policy updates is where district users can find the March 2024 policy update. Next slide, please. Now for County Office of Education users in your GPP sites, similarly, you'll use the policies drop-down menu to access CSBA Communications. And you'll see on the left, it's the County Office of Education policy updates that you are able to see, and you'll be accessing the March 2024 county update. Next slide, please. Now in the Gamut Policy Plus area for our GPP subscribers, we additionally provide PDFs of each supporting document, and then our 3 separate update packet types, which are the with notes, without notes, and track changes packets that we provide all together as PDFs. Additionally, the guide sheet, the checklist, and then the CSBA mandated and conditionally mandated policy list are provided as PDFs. Next slide, please. You can also pull the drafts of these samples directly into your manual using the links that are highlighted here. So we have our copy icon. The one that's lower down on the copy icon, which is the 2 pages, can be used to import an individual policy, and you can do them one by one if you're working on them individually. Whereas that copy icon at the top allows you to pull over the drafts of the entire update all at once in one click. You can also use the Word icon. Clicking on that will export the update document into Word. And then additionally, if you click on the links for the PDFs, you'll be seeing a version of the update without notes in PDF. Next slide, please. Once you use that copy icon to pull your drafts over, you can then find them listed out in yellow here as drafts in your GPP manual. And additionally, you can access them using your work in progress page, where they'll be listed out here by code and then who last modified them. Next slide, please. So if it comes to the point where you have found that your district or COE has missed several update packets, CSBA has some options for you. The first being the policy manual review, which is an audit that lets you know which policies you may need to update. It's provided in list format, and it helps you go through and determine using dates which ones you may need to do some catching up on. And then additionally, we also have the policy development workshop option, which updates your entire manual in one fell swoop with the assistance of one of our amazing CSBA policy consultants. They work side by side with you at your district to assist you in developing a policy manual in its entirety that's tailored specifically to the needs of your district or your county office of education. Next slide, please. So for GPP subscribers, so subscribers that have your own site for your manual and for your district or COE, if you also have Gamut meetings, something that you may be interested to know is that you can use those drafts from your policy module in your board agenda. And so you can pull them into your Gamut meetings module and link them directly to your agenda for any upcoming board meetings. Next slide, please. And there are a lot of benefits of combining Gamut Policy Plus and your policy module with the Gamut Meetings module. Of course, having everything together on one site allows you to access everything all at once. It's fully paperless, and it helps you save time and streamline with these modules interacting with each other, and not only that way in the example, but others. You also will only have one user database, as we know that can be helpful. So you can manage all your users in one place instead of replicating that work elsewhere. And then you can search across all of your modules using our advanced search feature that allows you to search them, the modules either together or separately. And then, of course, you can remotely access using your site. Next slide, please. Thank you very much.
Yeah, so thank you so much, Erin. So if you have questions for Erin on any of the technical aspects of the policy process, you can put your questions in the Q&A, and Erin, where she can, will answer in writing. And if it's either something of a more general topic or something Erin feels would be good to express in words, we can do it at the very end of our presentation. We'll have time for that. So thank you, Erin, for the really comprehensive look at that. And we'll move on now to the more towards content of policy. Okay, so next slide, please. So as an introduction to the updates, let's look at a brief description for each of the documents. So as we all know, we have board policies, which are the conduit by which the governing board legislates, and they articulate the policy direction of the district or county office of education. Next, there are administrative regulations, and this is the premise upon which the superintendent implements the board policies, and they provide the necessary details while staying within the confines of the applicable board policies. Sometimes we have exhibits with a certain number. We'll get into that a little bit more. So exhibits that either go along with a policy or an administrative regulation. And these will provide forms, notices, and other like tools, implementation tools consistent with the specific policy and or administrative regulation that it relates to. And then we have board bylaws, which are specific policies that provide the rules and procedures that governing the board itself and that the governing board must follow. So So this is what I was referring to above. So we talk about policies, and we kind of use this as an inclusive term for all of the documents I just stated: policies, regulations, exhibits, and board bylaws. So if you hear either in speaking with CSBA, maybe with other board members, and for sure during this presentation, that we say policies, we are, unless we a lot of times we're referring to the generic or the overall policies. All four of these documents could be included. So just to kind of keep that in mind as we go along, and it will probably avoid any type of confusion. And when we are referring specifically to a certain document, we make that very clear. All right, next slide, please. We're going to also look a little bit at our numbering system that we use. And as you can see, the policies within each series of numbers aligns with the content area of the policies themselves. For example, the 5,000s focus on students, 6,000s on instruction. Perhaps most difficult to understand is the 4,000s. These are the ones that deal with our employees, our staff. And they're identified as being appropriate for certain staff members by different numbers. So the ones that have a 1 after the 4, so the 4100s, would be for certificated staff. The ones with a 2, the 4200s, for classified staff, and the 3, the 4300s, are for management and supervisorial employees. Now, to make it even a little more complex, a given policy may be appropriate for 2 of the groups of employees, for example, like certificated and classified, or perhaps even all 3, classified, certificated, and managerial. And in this case, when it's 2, we call them double coded. When all 3 would be the same, we call them triple coded. And don't worry if this sounds confusing. It really shouldn't create any problems at all for you, but it is a good thing to know. And if you ever want more explanation, feel free to contact me or anybody else in the policy services group to explain it. But I think this should give you a clear enough idea moving forward about the basics of it. Just a little bit more about our policies. We have a lot of them. We have over 800 total documents for our samples. And this a little bit smaller in terms of code numbers, 550 code numbers, because as we talked about before, sometimes a certain code number has multiple documents. So like one code could have a board policy, an exhibit, and regulations. For example, uniform complaint procedures has 4 documents, I believe, in a given code number. Next slide, please. And let's now take a look at some general guidelines to follow when adopting policies. So keep in mind that policies are samples, and they serve as a starting point for your districts. But it is important to review them, and within the confines of the law, personalize them to your district. It's one of the ways that we can make as board members, that we can make our policies and our input unique to our district, which I know we all have certain things about our districts that we're very proud of and that we find unique. And this is a one way to do it. And it's through policy is a very preferred way of doing that. Please know that our samples have gone through extensive legal review, but they don't constitute legal advice. And they may become quickly out of date as new legislation and guidance is constantly evolving. We try our hardest to keep up with the new legislation and guidance. But even just in the drafting and our review time, sometimes we can become out of date. So please always keep that in mind. Our samples do contain notes that provide content and general descriptions for understanding. And they may be provided to board members, but shouldn't be in the version that the board adopts. So in the version that the board adopts, it should be just the body language of the document itself, not with the notes. All right, next slide, please. So what you see here is a complete list of the policies that were updated with the March packet, categorized by category. In our presentation, we will be highlighting and going into more depth on certain policies in each section. If you have any questions on any of the policies not highlighted or any of the materials discussed today, they can be addressed at the Q&As at the end of each section or at the end of the presentation. So we will have a Q&A at the end of each of our content-based sections. We will also provide contact information for further inquiries at the end. So if even after our presentation has been completed, you still have questions, feel free to email any of us, and you'll be provided the information at the end for how to do so. All right, next slide, please. And now what you're all here for are highlights from the March policy packet update. As I said, it's going to be divided into 4 categories: student health, which will be led by Meghan; student opportunities, achievement, and instruction, which will be led by Dustin; labor and employment, which will be led by Meghan; and board governance, which will be led by Josh. So I'm going to now turn it over to Meghan for a discussion about student health.
Thanks, Barbara. So I'll be focusing this part of the presentation on student health policies. So we'll be focusing our discussion on these first 3 bolded policies, which include the Comprehensive Safety Plan, Emergency and Disaster Preparedness Plan, and the COVID-19 Mitigation Plan. I'll briefly discuss the other policies on this slide. But as a reminder, all of the slides will be made available after the webinar for your reference. So if I go through the last half of these slides fairly quickly, please just know that you can always return back to this presentation. It'll be recorded, and then we'll also be sending out the slides as well. So next slide, please. So we'll be focusing our discussion for student health on the policies that are dealing with safety, since many of them have been impacted by SB 323, which was passed in 2023. And SB 323 requires comprehensive safety plans to include adaptations for students with disabilities in accordance with the Federal Individuals with Disabilities Act and Section 504 of the Federal Rehabilitation Act of 1973. The comprehensive safety plans were already required to include adaptations for students with disabilities in accordance with the ADA, but it added a new component as well. So SB 323 also requires that after each annual evaluation and review of the comprehensive safety plan, concerns about an individual student's ability to access the disaster safety plan procedures may be brought to the principal. And if the principal determines that there's a merit to these concerns, the principal is then required to make appropriate modifications to the safety procedures. So in addition to SB 323 changes that were made to BP and AR 0454, we also updated some of the AR language to reflect new laws, SB 671, which requires a comprehensive school safety plan to include procedures to assess and respond to reports of dangerous, violent, or unlawful activity that's been conducted or threatened to be conducted at a school, also a school-sponsored activity or on a school bus. We also updated the AR to include SB 10, and that requires schools that serve any of grades 7 to 12 to include protocol for a student suffering or reasonably believed to be suffering from an opioid overdose. And then we also updated the AR to include AB 1023, and that is providing schools with increased cybersecurity support. So next slide, please. And then we also updated BP and AR 3516, which is emergency and disaster preparedness plans. And so those have been updated to reflect SB 323, which, as we just discussed, requires school emergency and disaster preparedness plans to include adaptations for students with disabilities in accordance with IDEA and Section 504. The AR was also updated to include an attack or a threat of attack to the district's digital network and technology infrastructure. This was added to the list of emergencies and disasters that the district or the school site plans should cover. And then also routine monitoring of the security of the district's digital network and technology infrastructure was also added as part of the district's strategy and actions for prevention, mitigation, preparedness, response, and recovery. And then we also added a new note to the AR to reflect AB 1023. And again, that's providing schools with increased cybersecurity support. And there's also include automatic dialing services as a form of communication during an emergency, and expanding the list of critical information that would be needed in an emergency. The next slide, please. So those were kind of the safety policies that were updated. And then also we deleted BP 0470, which was the COVID mitigation plan. And as we all know, the COVID-19 public health emergency declaration ended almost a year ago on May 11th, 2023. So we're deleting this policy, and then future updates to other policies will incorporate the remaining relevant concepts. And so those include learning recovery, supplemental instruction, expanded learning opportunities, and chronically absent students. So next, I'm going to touch briefly on a few other policies, if you can go to the next slides. And those are mostly going to be related to food services. So these policies were updated to reflect SB 348, and that clarifies that districts are required to make available during each school day and free of charge one nutritionally adequate breakfast and one nutritionally adequate lunch to any student. And this includes if the district offers independent study, that the district must make available the nutritionally adequate breakfast and lunch on any school day that a independent study student is scheduled for educational activities lasting 2 or more hours at a school site, at a resource center, at a meeting space, or another satellite facility. So SB 348 is just kind of clarifying some of the existing requirement that districts make available those free meals to students. And it just tweaked some of the language a little bit. And again, that's the universal free meals for students. And so it doesn't depend on the student's eligibility for free and reduced meals. SB 348 also defined what a nutritionally adequate breakfast or lunch means. So we added that to the policy. And then SB 348 also clarifies and provides that students must be provided adequate time to eat. So that was added to the policy as well. And then there's 2 additional bills or laws, SB 95. And again, this is just clarifying something that we had already had in policy, but it's that districts may sell an additional nutritionally adequate meal that qualifies for reimbursement after a free meal has already been provided. And then SB 114 establishes some best practices for school meals, including serving freshly prepared on-site meals, using minimally processed, locally grown, and sustainable food, and giving priority to California grown or produced foods, and increasing plant-based or restricted diet options for students. So those were some best practices that were identified by SB 14 that we added to the board policy. And if we can go to the next slide, I'm still be talking about the same policy 3550. It was the policy was further updated to include concepts from the California Department of Food and Agriculture publication called Planting the Seed, Farm to School Roadmap for Success. And it's really talking about the benefits of school gardens, which include the impact on students' knowledge related to food and nutrition, and that it increases the school gardens, increase students' consumption of fresh foods and vegetables, and participation in school meals. So those concepts were added to the board policy, and we reviewed the administrative regulation, and we did some minor updates as well to that. And then moving on to BP and AR 3551 and 3553. We also reviewed these 2 and made updates, as we just discussed with the previous policy regarding SB 348, SB 95, and SB 114. And then we also added to the food service operations cafeteria policy that district funds may be used for purchase of school meals for students, and that's separate from the cafeteria funds. And then we also updated the BP 3553 to align the language, as we just discussed, with 348 and SB 95. And then for the regulations, we updated them and reviewed them and updated them for clarity and alignment with the board policies, as we just discussed. So then I'll be changing gears a little bit now and talking about administering medication and monitoring health conditions. So the AR was revised in December. And so for this packet, we made the corresponding changes to the board policies. So the board policy was updated to reflect AB 1283. And that authorizes districts to provide emergency stock albuterol inhalers to a school nurse or a trained personnel who have volunteered. And it also authorizes the use of inhalers to provide emergency medical aid to persons who are suffering or reasonably believed to be suffering from a respiratory distress. And then we also updated the board policy to reflect AB 1722, and that authorizes districts to hire a licensed vocational nurse following board approval that a diligent search was conducted for a credentialed school nurse. And so now I think we have a few minutes. If anybody has any questions related to the student health section, any of these policies, we can go ahead and answer some of those questions.
Thanks so much, Megan. And yes, we do have some questions. So I will look to those. I'll read them off and we'll do our best to answer. So
Okay.
the first one is, if you are a TK, so that's transitional kindergarten through 8th school, do you have to include high school policies?
So no, so the high school policies, well, if there is, I'll caveat that. So if one of the policies we just discussed is for schools that are serving students in grades 7 through 12. So if you have a school, a middle school or junior high school that serves grades 7 and 8, then you do need to have those policies because you're serving those students in grades 7 and 8. But if you have, so if there are certain policies that are only for high schools that are 9 through 12, and if your district only serves TK through 8, then no, you don't need to have those policies. And there are several of those policies in our manual. So if anybody has questions about those, that's a great question for our policy consultant team. And when they do go and do those consulting at districts, they would be able to walk you through if you're either a elementary school district only or a high school district only, and clarify which of those policies may not necessarily be applicable to your district.
Thanks, Megan. Yes, and one more little caveat is sometimes we have policies that have certain sections that are applicable to different levels of school. So sometimes there'll be a policy that might have just one section that's pertinent to 9 through 12, say, and that could be deleted by an elementary district. But other parts of the policy or AR would pertain. So it's always very careful to look carefully at exactly what the policy itself encompasses before making that decision. All right, next question. If a student wishes and there is food left over, can they be given free a second lunch or another piece of fruit?
So I don't think there's anything prohibiting that, but you would need to be careful of reimbursement, making sure that because it's going through federal reimbursement first and then state reimbursement, that you are complying with all of those requirements. You can have something like a share table where extra food is placed on a share table. And so if a student wants to go up to the share table and take extra food, like if somebody doesn't want an apple, they can put it on the share table and then another student can go up and grab that apple. That's perfectly acceptable as well.
Thank you. Okay, next one. Does that mean if a student already has a free breakfast, they have to pay for lunch, or is it dependent on the type of meals? I think the question Megan is trying to get at, is it a one breakfast and one lunch, or yeah?
It's so one each. So it's a student is entitled to one free breakfast at the breakfast. At my son's school, it's a snack period, but it's actual breakfast. And then they're entitled to a free lunch during the lunch period as well. But if they wanted to purchase another meal, so if they wanted to get a free breakfast and they were still hungry, they could go back and purchase a second breakfast. And then they would still be entitled to a free lunch But if they wanted to purchase a second lunch, then they could do that as well.
Okay, and our last question, I believe in this section, unless more come in while we're speaking. Can you elaborate on adequate time to eat for minimum days with no lunch period in the Bell schedule?
I am not sure on how many minutes is adequate time to eat. And I think that's something that where guidance will be coming down from CDE. So that's something that, you should be on the lookout for guidance, and we could always add once there is guidance about what the definition of adequate time to eat means.
Yes, I agree with Meghan. My recollection too is that more guidance is going to be coming out, and yes, we'll be looking out for it too.
Yeah, and it also doesn't prevent, having bagged lunches. So I know sometimes for our school, they'll, for minimum days or things like that, they'll have a bagged lunch that the students can go collect and then take home to eat.
Okay, thank you so much, Meghan. Next, I would like to introduce Dustin, who will lead a discussion about student opportunities, achievement, and instruction. So Dustin, if you could now begin your portion.
Thank you, Barbara. So I'm going to focus initially on the updates to the discipline policy, and we'll look briefly at awards for achievement, ceremonies and observances, recognition of religious beliefs and customs, and finally migrant education. So let's start with the discipline. Next slide, please. Focusing on BPAR 5144, because the changes from Senate Bill 291 will likely impact practices in many elementary classrooms. This bill prohibits recess restriction unless the student's participation poses an immediate threat to the physical safety of the students or peers. So the historical practice of sort of a recess detention or what have you is no longer allowed unless there are immediate safety concerns. Next, Senate Bill 10 is encouraging districts to consider alternatives to law enforcement for opioid misuse, and they encourage the use of restorative and/or MTSS type interventions to the extent that these alternatives are not in conflict with another law requiring a referral to law enforcement. Assembly Bill 1165 provides some encouraged practices to protect victims of racist bullying and to provide restorative practices to address the bullying behavior. Finally, we updated the language to reflect best practices and encourage the use of positive interventions and supports. Combined, these changes continue the trend toward moving educators toward finding more constructive responses related to student discipline. Next slide, please. BP and AR 5126, Awards for Achievement, was updated to reflect a couple new policies. Assembly Bill 370 revises the criteria for a student to be awarded the state seal of biliteracy. Additionally, Assembly Bill 181 established the California SERVES program to increase student participation in earning the state seal of civic engagement. Finally, we also incorporated existing statutes which discourage districts from charging fees to meet the requirements for district awards. Next slide, please. BP and AR 6115, Ceremonies and Observances. This was updated to reflect Assembly Bill 800, which requires districts to observe during the week of April 28, Workplace Readiness Week. And part of that observance is providing high school students with specified information on their rights as workers. Additionally, in grades 11 and 12, the observance are required to be integrated into regular school program consistent with the history and social science framework. Additionally, we made a quick addition adding that the death of a first responder in the state of California who dies in the line of duty is a basis for flying the national flag at half-staff. Next slide, please. BP and AR 6141.2, recognition of religious beliefs and customs, was updated to reflect a couple recent court decisions. The first one, U.S. Supreme Court, Kennedy versus Bremerton. The finding was that what we want you guys to know is that employees do not improperly coerce students to pray when they are acting in a private capacity. In this case, the football coach was acting in a private capacity when he knelt at midfield after games to offer quiet personal prayer. The second case was the Ninth Circuit Court of Appeals, the Fellowship of Christian Athletes versus San Jose Unified School District. The big takeaway from this case is that districts may not enforce rules in such a way as to disadvantage religious exercise compared to similar secular activities. In this case, the district improperly penalized the student club that required its student leaders to follow certain Christian beliefs by affirming a statement of faith and abiding by sexual purity, when it allowed other secular clubs to impose requirements for membership or leadership positions. These BP and AR were also updated to state that instruction regarding the role of religion in society will be consistent with adopted instructional materials and state standards. Finally, we have BPAR 6175. Next slide, please. Migrant education. The big addition here was related to SB 532, where we were incorporated the requirements related to the transfer of coursework and credits for students who are migratory, and added that the eligibility criteria and procedures for these students being eligible for an exemption to district established graduation requirements. This language is also detailed in 6146.1 high school graduation requirements. Next, Assembly Bill 1777 addresses the extended school year program authorization and funding for specified students who are migratory. A couple more minor and technical changes to this policy is we aligned with Ed Code and CDE's federal program monitoring, adopting the use of the term students who are migratory. We also added a statement that programs for online instruction may be provided as a substitute for physical attendance. The number of summer school instructional days may be decreased if there is a holiday for which schools are required to be closed. And next, requirement that districts to make their facilities available to other agencies for migrant summer school programs unless just cause exists. Finally, we deleted outdated material regarding Even Start Family Literacy Program because that funding no longer exists. Next slide, please.
Thanks so much, Dustin. So now we'll
Yeah.
take a little time for questions on this topic, and we do have some.
Great.
So the first question is under SB 291, so that's the recess one. Does the denial of recess include lunch? Also, is there a grade span this applies to? I can go ahead and try on this one. So is there a grade span this applies to? I actually just looked into this, and I don't know if there is a clear answer. I looked into it in drafting for June. And I believe it applies to K through 8. It's not, as far as I could see, it's not in the code section itself, but I looked a little bit into the legislative history, and I believe it applies to K through 8, but I do want to confirm that with as we update our policies and go through our review process. So stay tuned for that. But my intuition and my belief from what I've read so far is that it's K through 8. Does the denial of recess include lunch? That also is a good question. The bill and the law is specifically to a designated recess time, depending on the minimum day schedule or a regular schedule. It'd be 30 minutes for regular, 15 minutes for a minimum day. So I think this would apply to that recess period, but that is a good question that we should confirm that that's the answer to.
I believe there's existing regulations or policies that you can't deny a student lunch.
Correct, in terms of the lunch, yeah.
Right.
I'm thinking, yes, you're exactly, Dustin. Then we should look further into the recess following the lunch, the eating time, but yes, I agree. Yeah, thank you. Okay, next question. Under SB 291, can we hold a student back and have them go to recess late? What about denying recess for other reasons such as tutoring?
Tutoring would not, for disciplinary reasons, it can't be denied. It doesn't specifically address tutoring. I would really give that some consideration as a practice and make sure it's not being punitive, I think would be the goal. And so you're going to want to have to really consider the circumstances and make sure that it's not going to be construed as related to discipline.
Yeah.
Is there a
Yeah, my
second part to
understanding
that?
is, yeah, unless there's an immediate risk to the student or to the student's peers, yeah. So, okay, next question, is 5126 optional? Is the first part of the question. And I went back to our mandate list to double check. And it is a conditionally mandated policy, which means that if you do offer the awards, granting awards for students, and there are certain laws that need to be followed. It's also conditionally mandated for districts that have established a scholarship and loan fund regarding rules for the committee selection and governing applications. So conditionally mandated means that if you operate it, then you do need to have the policy. If that helps with understanding what conditionally mandated or mandated means.
So am I right, Barbara? Like in this case, if you were wanting to give out the state seal of biliteracy, then you would need to adopt this policy?
Exactly. Good example. Yes, exactly. Correct. Okay, there was a second part, I know, actually 3 parts to this question. Is it just for LEAs with high schools? I think they're meaning about the whole policy 5126. And no, it could also be offered to, if you have students in elementary grade levels that you have set up a structure for, I believe you would still want to adopt this policy, need to adopt the policy if you're giving out awards. Dustin, I don't know if you have any further comment on that.
I believe it, I think it's focused on secondary, but I believe it would be possible for other students to meet those requirements if districts are distributing those awards.
Okay, and then there was a question too about 6115, and I think the question was also, is it mandated? And it's another conditional mandate that for districts that maintain secondary schools, the rules regarding implementation of daily patriotic exercises. So if you maintain a secondary school, then 6115 would be a mandated policy. All right, let us look at the last question for this section. Please give an example of charging fees to obtain district awards. What about NHS and CSF participation in dues? NHS is national.
I'm not positive on dues. The intent of it was to sort of, because you have to take sort of if you have to take the SAT as a part of getting this biliteracy, so students be eligible to receive some reimbursement or support if they can't afford to pay for those SAT or the exams on their own.
That is a good question though about participation dues, and I don't know the direct answer to that. It's something we should probably research and know. Yeah, but
this was adopted based on the general equity policy and ensuring access. So we don't want to deny students access to receive the awards because they can't afford to take the test. I don't think you would need to be a part of NHS to be eligible for these awards. So I don't know that it would apply in this case, if that makes sense.
Yeah, I think you bring up a good point, Dustin. And I think the question is a little more general to what we're presenting on right now, but does bring up a good point about participation in dues for these other types of, it's not necessarily an award, but another type of honor that a student can get recognition for at a school.
Yeah, if they want to send an email, I'd be glad to do a little additional research, or we
That
can
would be
follow
great.
up if
Yeah.
that didn't answer your question well enough.
Yeah, no, I think it was a good answer, and I think I agree, and I agree with your idea to fall back to the general reason is the equity. And if it's gonna prohibit some students from participating, even if we find that the law does not address that, each district needs to think about if that would be a good practice to follow so that we could keep following these more general rules of equity. All right, well, thank you, Dustin, for the very thorough presentation. And next, I would again like to introduce Meghan to come back, and we will hear from her about a discussion about labor and employment.
Thanks, Barbara. So for this portion of the presentation regarding labor and employment, I'll be focusing on, again, those policies that are bolded. And I'm focusing on these ones because they are all impacted by SB 700. And that is prohibiting employers from discriminating from applicants or employees based on cannabis use. So for the first two policies, those are focusing on applicants. And then the second two policies are focusing on employees of the district. And then we'll also briefly be covering the last three that are noted on this slide. Next slide, please. If you see at the top of this slide, we have BP 4111, 4211, and 4311. So they're all policies on recruitment and selection, but they're what we call triple coded because the 4100s, so BP 4111 is dealing with certificated staff. The 4200s, so BP 4211 is dealing with classified staff. And the 4300s, so 4311 here, is dealing with management and supervisorial staff. And that also applies to the AR here, which is discussing criminal record check. So both of these have been impacted by SB 700. SB 700 applies to all California employers. And so districts are prohibited from requesting information from an applicant about their prior use of cannabis. And this is apart from criminal history. Unless the district is otherwise legally permitted to consider or inquire about that information. So, districts are in a little bit of a unique situation because we have employees like bus drivers, and those go through a more extensive background check. And so we're also clarifying in this policies and ARs that districts retain the right to maintain drug-free schools, and to prohibit employees from possessing, being impaired by, or using cannabis while on the job. And so we've also updated the board policy to reflect new guidance from CDE, which is entitled How to Increase the Diversity of California's Educator Workforce, and from CTC, which has a strategic plan ensuring educator excellence. And both of these documents discuss the benefit that students receive when staff reflects racial, ethnic, linguistic, and cultural diversity, and when recruitment and selection processes seek to establish and maintain a diverse staff as well. The policy was also updated to include that employers with 15 or more employees, including districts, are required to include the pay scale for a position when they're advertising for an open job. And then we reviewed the exhibit about criminal record check. It was reviewed, but there were not any material changes made. Next slide, please. And so for the last group of policies and ARs, they were triple coded. So it was basically the same policy for all types of staff, certificated, classified, and management. But for BP 4118 and 4218, there's slightly different requirements for certificated employees versus classified employees. So these are not triple coded. There's two different distinct policies. So 4118 is for certificated employees and 4218 is for classified employees. We did make several changes that applied to both policies. And then there were some changes that applied only to one or the other. So for both of the board policies, we added a new court case, which just came down from the Fifth Circuit Court of Appeals. And the decision was Visalia Unified School District versus PERB. And the court held in that case that service as a union officer constitutes protected activity for purposes of complaints of retaliation for union activities. So based on that holding, we added language to both board policies, clarifying that retaliation solely for engaging in protected activities is prohibited. And then also for both board policies, we added a new section, and the heading is compulsory leave for absence. And that was just to bring the board policies in line with the ARs that also have that section. And it's about the fact that districts are required to place employees charged with a certain mandatory leave of absence offense on a compulsory leave of absence. And then for AR 4118, we expanded an existing note, and it was explaining a multiple factor test in the case Morrison versus State Board of Education. And that is determining whether a teacher is fit to teach. And so that's why that's only in AR 4118 dealing with certificated employees, since it does not apply to classified employees. And then we also added a new note in both of the ARs, and that is that discrimination based on employees' use of cannabis when off the job and away from the workplace is prohibited. So next slide, please. And then this is regarding bargaining units. And again, this is one of those triple coded policies. So it applies to all these certificated, classified, and management. And it's one policy, a similar policy for all three. They're not distinct based on the type of employee. So the board policy was updated throughout to clarify the use of those terms, employee organization, recognized employee organization, exclusive representative, and bargaining unit. And then we updated the board policy regarding PERB opinions, when the district may restrict the wearing of buttons, insignia, or other political or written messages by employees. And then also when districts may limit employee organizations' ability to communicate with its members, and what constitutes reasonable restrictions by a district. And then we updated the board policy note and references to include AB 243, and that is a safe at home confidentiality program. And so there's an existing safe at home confidentiality program that's been in existence to protect victims from domestic violence, sexual assault, stalking, human trafficking, and elder and dependent abuse, as well as district employees who face threats of violence or harassment from the public because of the employees' work for the district. And then this type of protection has been extended by AB 243 to victims of child abduction and members of their households as well. So we added that to the note in the board policy. And then we removed outdated material from the board policy related to COVID-19 and clarified, reorganized, and aligned the policy with law. So next slide, please. And then the last thing I'll be talking about as part of labor and employment is board policy in AR 4157, 4257, 4357 related to employee safety, and AR 4157.1, 4243. So again, those are all those triple coded policies and administrative regulations. So the BP 4157 and AR were updated to reference SB 553. And so starting July 1st, 2024, SB 553 requires districts to establish and maintain in all work areas an effective workplace violence prevention plan. And so it has specified components that must be included in the workplace violence prevention plan, as well as the workplace violence prevention plan and SB 553 also requires districts to provide employees with training about the plan as well. And this is a new annual requirement. And then AR 4157 was updated to include that OSHA may prohibit entry into a place of employment when it's, in its opinion, the place of employment exposes employees to an imminent hazard. So that could include something like COVID-19 or any other hazard. And so with the addition of that language, we also updated the ARs to remove some outdated specific COVID-19 material. So next slide, please. So if there's any questions on labor and employment, I'd be happy to try to answer those.
Thank you, Meghan. And yes, we do have a few. The first is 4218 listed in the checklist in the packet? I believe it is, but Erin might actually be able to fill us in a little bit more. It should be. We did update 4218 with the packet. The person who wrote it in said might be my mistake, or maybe it was our mistake. I don't, so why don't we double check? It looks like Erin's come back to help us.
Yes, that's okay. And thank you for your question. Because we arranged the checklist where in the 4000s, the triple codes are organized together, the 4218 policy and regulation actually fall at the end of the 4000s, and they're on the following page. So you'll find them on the top of the checklist on page 3.
Thank you so much, Erin, and thank you for joining us again to help with our technical questions. Really appreciate it. All right, next question. Is compulsory leave of absence, that term, that legal, is it a legal term that we must use? The district is asking, I guess they've been using a term administrative leave of absence. Is that term okay to use, or should it be compulsory leave of absence?
Josh may want to weigh in on this too, but I don't think you're required to use that term. You are required to place an employee on leave if they've committed one of these mandatory leave of absence offenses. But I don't think, if you're titling your document administrative leave of absence, as long as it's complying with the requirements of law, I think that's okay. But that's definitely something that you would want to run by your legal counsel.
Yeah, said perfectly, Megan. Nothing to add.
All right, and our last question, would the workplace violence prevention plan be part of the safety plan, or is it a standalone document?
So I might need some input from Barbara, but I believe
Sure.
it can be integrated into the existing, there's another plan called forget what it's called. I have to double check it. But it is mentioned in the policy that is dealing with employee safety. There's an existing illness and injury prevention plan. That's what it's called, injury and illness prevention plan. And so the workplace violence prevention plan can either be integrated into that existing illness and injury prevention plan, or it can be a second standalone document.
Yeah, I would agree with Meghan. It does. It is part of that plan that Meghan referenced. The only one caution I would put is there's a lot of requirements for this workplace violence prevention plan. So I would caution to really check them all out. There's very specific requirements for it, and for training and for logging. And I would just make sure to actually go to the law, and it really spells it out very clearly what the requirements are. So yeah, it is a standalone document, but I think you would want it to somehow be incorporated into your the more general injury and violence prevention plan document. So yeah, or injury and illness plan. Yeah. So if it is a separate document, you would somehow want to reference it by incorporation, I would imagine. So, all right. So, well, thank you, Meghan, very much. And we're going to move on now to our last portion, which is going to be led by Josh. And to lead a little discussion about board governance, I believe he's going to discuss one of the board bylaws that we updated.
Thank you, Barbara. Yep, only got a couple board bylaws to cover, so this shouldn't take too long. We'll start with board bylaw 9323.2, actions by the board. It also has 2 exhibits, and we updated both the district version and the county version. Substantively, they are mostly similar. So with respect to the board bylaw itself, we added a few notes. One of the challenges is when a board member requests to participate remotely due to emergency circumstances, like what do you do then, particularly if the request is made after the agenda is posted. So we added a note about that it's basically taken up at the beginning of the meeting. We also added some language about sort of similar to that, how to handle that. And then there was a whole section in this board bylaw about challenging board actions, and it laid out the law with respect to what like the DA, the district attorney, could do, which isn't really applicable in some sense. We don't want our board policies to empower anybody else. They're really for us, for the school board, for the district, for the staff, families, for the students. And so we removed that and basically said, look, if you're in this situation, you got the DA coming for you, talk to your attorney about it. And let's not in our board bylaw say exactly what the DA should do. Connected to that, we're going to jump over Exhibit 1 for a second and into Exhibit 2. Exhibit 2 was a draft letter that you could use if somebody alleged a Brown Act violation, because a lot of what the board bylaw talked about was Brown Act stuff and actions taken consistent with the Brown Act. In reality, when you get one of these accusations, you're going to want to talk to your counsel. And so Exhibit 2 was this draft letter that a few districts had used to respond, but in practice, it wasn't, I think, even though it is using language in state law that has safe harbor provisions in it, so it was valuable in that sense, you're going to want to talk to an attorney before you respond, because Brown Act violations can be quite serious. I'd say most of the substantive things to be aware of here have to do with the changes to Exhibit 1. So a few folks had read the list. So Exhibit 1 talks about primarily, it provides lists of actions that are sort of unique in some sense. So the first list is things that require more than a simple majority. So 2/3 or unanimous vote or 4/5. And then we added a few other lists, but those actions are not intended to be exclusive. So there may be actions that require 2/3 that are not in the list. We do our best to capture them, but we've not memorized the ed code or the government code, so we want to make sure to re-emphasize that don't take this list as exhaustive. We did clarify a few things on the 2/3 list. There's some language around decision versus resolution of intent with respect to GO bonds, and there was a reference to parcel tax placing it on the ballot by sort of an old code provision, and there's actually one that exists separately that requires a majority vote, and so we sort of corrected that. And then we added a list of actions that are required to occur during a regular meeting. So you cannot terminate a SUP or an assistant SUP without cause at a special meeting. It must be at a regular meeting, and then you must discuss contracts, salaries, etc., about those upper management positions at a regular meeting as well. Basically, this is to avoid boards from sort of being sneaky around it. And then there's also a list of prohibited actions under certain conditions. So you can't terminate without cause a SUP or assistant SUP within the first 30 days of an election. And then there's something about if you're disposing of surplus property and you get a notice from the Department of Housing and Community Development, you have to hold a public hearing. It's pretty specific on that one. So, if you're in that situation, definitely, make sure you're paying attention. So that's the first board bylaw we'll talk about. And then the second is 9320, meetings and notices. As with the previous one, very similar districts and counties. I should have noticed on this exhibit, some of the things in the list, that is really where the differences are between districts and counties. Some of the things that apply to districts do not apply to counties. And so make sure that you are taking a clear look at that and applying the right list to your LEA. All right, meetings and notices. So we did a few other changes here. So we added a note So under the Brown Act, a special meeting can be called by the board president or the board majority. And the situation comes up, well, what if the president doesn't want to call a special meeting, but a board majority does? How do they get together without themselves violating the Brown Act to call a special meeting? And so it makes some suggestions on how you do that, primarily using sort of a superintendent or secretary, right, to help facilitate that in a way that doesn't put you at risk under the Brown Act. We clarified some language that, if you have a study session or a public forum, really anytime the board gets together, it must either be a regular meeting or a special meeting or some sort of non-meeting exception. We've seen a situation where a district is like, oh no, I have a study session. That's not a regular or a special. Yes, it is. It has to be one or the other. There were some clarifications needed in terms of remote meetings that we added. AB 557, which extended the emergency circumstances and just cause bases for remote participation. And then under a proclaimed state of emergency, that authorization is extended indefinitely. And then one of the things that it just, I think, reflects the poorly written nature of sort of how the law is at this point is that there is one limit on just cause alone, which is 2 per year. And then there is a separate limit, which is either emergency circumstances by itself or together with just cause, 20% of regular meetings or 3 consecutive months. So it's kind of confusing. You have to like jot it on a piece of paper with it, I figure it out. So just pay attention to that because you don't want your board members getting in trouble for using these bases too much. And with that, we'll just jump to questions.
Yeah, so far there are no questions in the on this topic, but we will give our participants a little time because if any were not captured yet, we can address them at the very end of the presentation, which we're getting close to. So I'm going to go very quickly through our other slides here before we get to the end of the presentation questions. So next slide, please, which is our second poll, I believe. And the poll has to do with how you would rate us. So if you could take a few seconds to let us know how we're doing, really, like I said before, just so we can serve you better. That's the point of this whole poll, is just how we can do our job better. Take just a few seconds. Okay, let's give it like 5 more seconds. 5, 4, 3, 2, 1. All right. And do we have results? Let's see. Well, that's good. It looks like most found really helpful. Then another well, the large percentage is either really helpful or incredible. So that's great. And then there's the good enough. Hopefully we'll hear from you, the good enoughs of what we can do to do better. But excuse me, I appreciate you all, participating in the evaluation. That's really great. And then the next slide is going to show some contact information. So if there's any questions that you have remaining after the presentation or any concerns or issues that you would like to address to us, and if any then go towards our legal services, just to know that CSBA does have a legal services department now. Policy questions sometimes do cross over with that. Here is the contact information for those 2 departments. And now we'll go to our final Q&A. So let's get to that quickly. We've got just a few minutes. We'll try to get through it fast. The first question is, do changes in ARs need to be approved by the school board? And the quick answer is no. The administrative regulations are really meant for implementation by administration. So they do not, whereas board policies do need to be adopted or even if there's a deletion to be done by the school board. No, the board does not need to. A lot of boards like to be informed about the ARs. So that's the answer to that one. Second question, when a district has personalized a policy, how do we keep track of sample policies with our own personalization? Or is there a best practice to compare? This does get tricky. Because if it's a policy that we have, and we're updating, then you could check those sections that we've updated to make sure those are current. The sections that you might have different, I would recommend maybe reviewing with legal counsel or really probably better CSBA Legal Services only because they're very familiar with policy, but really either works. Either the CSBA Legal Services Department or your own counsel. If it's a separate policy that you've created that we don't have at all, then again, I would either contact and have your own legal counsel look it over or CSBA Policy Services. I hope that answered that question, but I think that's what that was getting to. Here, and now we have two that are less general, more about the topics we covered. If we don't participate in the National School Lunch Program, do we need to have a BP? As a charter school located on a military base, we partner with the National Guard who provides meals. Megan, do you want to take that one? Or you want me to?
I don't believe you need to have a BP. But Barbara, if you have any insight on that.
Yeah, my understanding is that if you don't participate, you don't, the policy is really a requirement to have a meal charge policy. So my understanding, yes, is if you don't, if you're not, it's more of a conditional mandate. If you're not participating in the National School Lunch Program, you don't have to have this meal charge policy. Yeah, so I think you're okay without, and also in terms of achievement data, like which appears in 3553 and using the NSLP information for other purposes. I also believe it's a conditional mandate. So if you're not using, receiving money and not participating in the program, I don't believe you would need to have that policy. I believe both of those are conditional. And so I think the answer is no. Some of these border a little bit on legal advice. So I get a little nervous, but that's why I keep qualifying, but I believe the answer is accurate. Okay, regarding board policy 514.21, how does the school obtain stock emergency inhalers without a prescription? Are we required to have them in stock? Dustin, did you want to help out this one or you want me to cover it?
Yeah, I'm glad to. It is not mandatory to have them in stock. And the policy states that a nurse or health practitioner, or if one is not available in a smaller district, an administrator can obtain a subscription by working with a doctor.
Thank you. And Dustin, is this the one where the county offices might be receiving?
No, that was the opioid.
Okay, that's good to know though, for districts to
Yeah.
know and county offices to know. There is, if you look into the AR, there is one of the authorized emergency medications that the County Office of Education might be able to help you out with in terms of obtaining it. Okay, and then the last question, I believe, let me just scroll down and make sure. Oh, okay, we got two more questions. For SB 291, what about benching outside, not inside a classroom during recess? Dustin, do you want to handle that? Or?
Again, the policy is pretty clear. Only you can't restrict recess unless there is a threat to safety. So I would be pretty reluctant. Again, I don't want to give legal advice, but I would definitely look very closely at this practice, because if it's a form of discipline or punishment, even if the child is outside, I think you may be violating that regulation.
I agree with you, Dustin. It seems to be very specific to immediate threat to the student safety or to one of the student's peers. So yeah, I think you have a great answer. And then the last question, we're a little bit over, but let's try to get to it. Can you talk a little bit about mandated and conditionally mandated policies? So we keep a list of policies that are mandated, and we try to always in that policy that it refers to say if it's a mandated or a conditionally mandated policy. And mandated means that the policy itself is required. Often we have policies where the law is required, but the law does not require a policy on it. A mandated policy means that the law requires that a district or county office of education has a policy on that topic. Conditionally mandated means if the district participates in a specific program, then they are required to have policy on that topic. So I think that should explain it. Maybe one of my peers can help if I did not explain that properly, but the idea, the part that gets very confusing is there's a lot of laws that districts have to follow. But when we talk about a mandated policy, it's a law that says you have to have a policy on that topic. So I think that's the easiest way to understand it. Or like conditionally mandated, if you participate in that program, the law says you need to have a policy on that topic. So yeah, I think that's the simplest way to understand it. And we do have a list, which I believe as members you have access to, which is a mandate, we call it our mandated policy list, which has, it's a chart which includes all that information. So I think that's about it. I really thank you all for your attendance and for coming to hear and learn. And I hope you enjoyed it, found the webinar informative and helpful, and just hope you have a great rest of your day. And thanks to all of my peers who presented. And so that will conclude our presentation.